This is Hubwonk. I'm Joe Selvaggi. Welcome to Hubwonk, a podcast of Pioneer Institute, a think tank in Boston. U.S. presidential elections have two distinct phases. First, the election administration itself, managed entirely by each of the 50 states and the District of Columbia. And second, the counting of the states' results in Washington, D.C. Owing to the U.S. Constitution's vague guidance on the proper administration of presidential elections, Congress further defined election procedures in the Electoral Count Act of 1887, which continued to recognize the primary role of each state to designate its slate to the Electoral College, and leaving Washington the largely administrative role of counting those electors. This law had remained untested until 2020, when, following an election defeat, the outgoing administration, along with a substantial number of House and Senate members of his party, sought to exploit the perceived weaknesses and ambiguities of the law by objecting to the election results of several states. Indeed, buoyed by the belief that Congress and the Vice President could use the Electoral Count Act to delay or overturn the results of the past election, rioters on January 6, 2021, stormed and occupied the Capitol building. The chaos and resentment that ensued from this event has led members of both parties to consider modernizing the Electoral Count Act in a way that reduces confusion and discourages misbegotten challenges from any losing party or candidate. What is the Electoral Count Act? How did its ambiguous language encourage the 2020 challenge to state electors? And how can legislators rewrite the law in a way that reassures the parties, the states, and the electorate that our presidential election process is sound? My guest today is constitutional scholar and research fellow Thomas Berry. Mr. Berry and his colleagues at the Cato Institute's Robert A. Levy Center for Constitutional Studies have written extensively on the history of the Electoral Count Act and the need for its reform. Mr. Berry will share with us the intent of the original act, the steps our legislators are now considering to modernize the 1887 law, and his suggestions for additional improvements that will help protect the integrity of the way we elect our president. When I return, I'll be joined by constitutional scholar Thomas Berry. Okay, we're back. I'm Joe Selvaggi. This is Hubwonk, and I'm now pleased to be joined by constitutional scholar and research fellow at Cato Institute, Thomas Berry. Welcome back to Hubwonk, Tommy.
Thank you. Thank you for having me.
Well, we're going to go deep on a topic that is now being debated in both houses of Congress, and I think at least the spirit of the debate is also being in the minds of many Americans. So I want to take it slowly. We're going to be talking about presidential elections, specifically the Electoral Count Act and perhaps its reform. But before we get deep on the wonkiness of this particular topic, let's give a little bit of background to our listeners who are not constitutional scholars, who do not study this all day long. We know the Electoral College in general, it's some sort of intermediary between me, the voter, and how the ultimate count of votes for president of the United States, how they're counted. Can you explain to us the spirit or the history of the Electoral College? How did we get here?
Absolutely. So maybe the first answer to how did we get here as it relates ultimately to the Electoral Count Act is we got here through the framers not thinking a lot of problems that we're having would ever happen, or not thinking we'd ever have the kind of controversies we've seen. So the original Constitution lays out and explains that states decide how they're going to pick their electors. Today, every state has a general election. In the early days, some had their legislatures choose. It's up to each state's law to decide how it's going to do that. And then the Constitution lays out pretty specific rules for how the electors meet and vote. They each meet separately in their own states. The intention was for them not to kind of form a cabal and strategize. Obviously, that hasn't turned out to be the way it works. Nowadays, they're all pledged to people and candidates in advance. They meet in separate states, they write down who they're voting for, and they mail it to Congress. And it seems it's not entirely clear why mailing it to Congress was done, but it basically that was just sort of the presumption of where else is everyone going to be gathered from all 50 states to kind of have one specific locale to see who's going to be president. And so the Constitution says all groups of electors, send them, at the time it was 13 states, now it's 50 plus DC, mail them to Congress. It says the president of the Senate, that's normally the vice president, if there is one, shall open them, and then it switches to the passive voice. And as any grammar school teacher will tell you, the passive voice, the problem with the passive voice is it doesn't tell you who's doing the action. It says the votes shall then be counted, period. Doesn't say who does the counting, doesn't say anything about how the counting happens. It just assumes they shall be counted. Most likely, they didn't think there would be any controversy. It's not that hard to do math. Have a teller. In the early days, it would just be a teller would read out, 5 votes for so-and-so, 12 votes for so-and-so. But we started to have some controversies. The biggest one by far was the 1876 election, the famous Tilden versus Hayes controversy that lasted months and months, kind of the Bush versus Gore of the 19th century. Almost, I think it's fair to call it a full-blown constitutional crisis. The president was really not known who was going to be sworn in up to a couple days before Inauguration Day, which was March 4th at the time. Multiple states were in controversy, and multiple states sent competing slates of electors to Congress, a Democratic list and a Republican list, and it had to be decided which one was valid. And so after that controversy, Congress really realized, okay, we need to actually have a procedure in place in advance, so we're not solving these problems in the spur of the moment with rules made up on the spot. Because when you make up rules on the spot, there's inherently a partisan tinge to them, and people will assume you're making the rules to help your side. So for about 12 years, they debated how to deal with this. And finally, in 1887, they passed the Electoral Count Act, which is what we're talking about today. And that set out the procedure for the count, that it goes in alphabetical order. The vice president reads them out. And crucially, it said if there's any controversy over whether votes are valid or not, you have to have a challenge initiated by one member from each body, a senator and a congressman. And then you have a strict 2-hour debate, and then you have a straight up or down vote whether to count it or not. And if both houses vote to toss it out, you toss it out, otherwise you count it. And the hope was that would streamline things, it would prevent filibustering, and it would allow for a choice one way or the other to happen the day of the count.
Okay, so we've had, by my reckoning, since the ratification of the Constitution, 59 presidential elections, and you talked about one catastrophic, or I guess hotly disputed result. I guess this is post Civil War Reconstruction period in our history. So a lot was going on there. So you identified the problem, which happened in the 1886 election, and the resolution, which is the Electoral Count Act. Presumably, we resolved the problem, and yet here we are. Have there been other challenges similar to the one you described, other crises in choosing a president since the act was passed?
None is full blown, but yes, we've had a few instances where there have been controversy, and the Electoral Count Act has seemingly not been that great at giving guidance of what's a valid challenge and what's not. In 1960, there was a long recount in Hawaii that first went to Nixon, then it went to Kennedy. Both Hawaii submitted votes for both, and Nixon kind of magnanimously, he was vice president at the time, so he just magnanimously said, we'll count the votes for Kennedy. That was probably not the right thing to do because it didn't set a precedent, and it almost implied that it's the vice president's choice when under the act it's clearly not. We then, of course, had Bush versus Gore, a big controversy. There was an attempt to challenge the votes for Bush from Florida during the count, but there was several members of Congress challenged it, but no senator challenged it. And without a senator joining in that challenge under the rules of the ECA, you can't have that 2-hour debate. Then in 2004 election, we did have a valid challenge to Bush's electors from Ohio because they finally got a senator to join, Barbara Boxer. Challenge didn't go anywhere. No one else voted to uphold it, so those votes were counted. We had similar challenges in 2016. Several challenges were attempted to President Trump's electors from multiple states. No senator joined on. And then, of course, we have 2020, where it got a lot more attention than normal because several Republican senators objected to Biden electoral votes from multiple states. And this was the plan they had, to use the electoral count to challenge Biden electors from Arizona, Pennsylvania, a few other states. And of course, this was going on at the same time that the Capitol was breached and ransacked. And in many people's view, the possibility, the hope, or perhaps false hope, that the ECA could be used to overturn the election was part of what created the fervor that led to the Capitol being ransacked. And that's a big reason for the current push we have, which is to clarify what you can and can't do under the ECA.
So we're looking at, you went step by step through all the problems when you have an ambiguous law that doesn't clearly define the rules. You invite people to exploit the ambiguity and perhaps give oxygen to those who would challenge a result. But it sounds as if really the Electoral Count Act didn't really come into play in the other disputes you described. For instance, the 2000 election, Bush v. Gore, I think that was resolved in the courts, not elsewhere. Is there a balance? I mean, what prerogative does the court have, and again, what prerogatives do states have? We'll take those in turn, but beyond those objections made by senators and congressmen in 2020, how other ways can we resolve a dispute as to who wins a presidential election?
Right, exactly. That was really the intention behind the ECA, was that the drafters hoped it would be the courts, almost always, that would resolve these issues, specifically issues related to the conduct of the general election. So if there's an allegation of fraud, an allegation that a state's balloting rules weren't followed, and any sort of allegation that the general election was not handled in a legally proper way, that's not for Congress to litigate. That's for the courts to litigate, for several reasons. Courts are better equipped. They have more time. You can't answer these questions in 2 hours of debate on the House floor. Courts can hear evidence. Courts have about a month between the general election and when the electors meet. That's not a ton of time, but it's way more than Congress has. And so the Electoral Count Act was designed in such a way to allow those issues to be resolved. And then it specifically has a clause called the safe harbor provision that says if a state's electors have been challenged and litigated and the final decision has been made by the state's highest court, that's final. That's binding on Congress. Congress can't second guess that and say, no, we think there was fraud in the election, so we're going to toss out these votes. So besides what the Electoral Count Act was intended for, it uses vague language. It says you can toss out a vote if it was not regularly given or lawfully certified. And a big problem is that that's pretty vague language. And 130 years later, we have even less of a sense of what it meant 130 years ago. But it seems clearly to have been intended to be limited to problems clearly on the face of the ballot. The electors did something wrong. They met on the wrong day. They didn't sign and certify it in the right way. Those kind of implausible but still possible flaws with the votes themselves, not relitigating the general election.
So let's put a finer point on it. We're going to talk about 2020. This conversation about reforming the Electoral Count Act is public knowledge. The former president actually used sort of the debate as to how we can improve this act as evidence that there were prerogatives that were not exercised. Specifically, he maintains that the vice president had some prerogative to choose to throw out certain ballots. Is there, as you say, the passive voice was used, as I am right now using a passive voice. Is there some validity to the notion that there was a prerogative by the vice president? You mentioned Nixon magnanimously the Hawaiian votes he gave to his opponent, but would it have been in any way, shape, or form the prerogative of the vice president, the president of the Senate, to have discarded some votes?
I don't believe so. The constitutional argument basically presumes that when it says the president of the Senate, which is the vice president, opens the envelopes, the argument goes that, well, since he's the one holding the votes, he's naturally the one who should also be counting them. That even though it switches to the passive voice, the person holding the votes is the natural person who should count them. And there's also a quasi-originalist argument, an attempt at an originalist argument based on original practice. There are some claims that in the early 1800s, Thomas Jefferson, when he was vice president, and then in the election where he was elected president, essentially made the decision on whether to count votes from Georgia. There was a dispute about whether they were submitted in the correct way. That's disputed. One is just a historical matter. It's disputed whether, in fact, Jefferson was the one making that choice, or whether he was simply presiding over the session and saw that no member of Congress was objecting to it. But I think the bigger issue is that the Constitution is, to say that the vice president has this prerogative is to say that it's so clear from the text of the Constitution that the vice president inherently has this prerogative, even if a statute says otherwise. And I just don't think the text of the Constitution requires that. In other words, I think it leaves a gap that can be filled in multiple different ways by choice in the text of a statute. And so I think the Electoral Count Act validly made a choice, and I think a good choice, which is it makes more sense to put that decision in both houses of Congress rather than unilaterally in the vice president. One, it's a bad idea to have so much power in one person's hand. Two, the vice president is very often a partisan figure who's involved in the election, either running for vice president or president. And so it doesn't make sense to put such an important choice in someone with such a big stake in the outcome.
Yes, clearly there's a conflict of interest when you're the one on the ballot. So it seems an unlikely thing. So let's just take a step back. We're talking about electing a president of the United States, rather important decision. And you've described it in two different phases. One at the state level, where each state governs how it conducts elections and then sends those electoral votes to Washington. And Washington effectively opens the envelopes and counts the votes. But there is a process for objecting to those votes. You alluded to it a little bit earlier that a single congressman, a representative, and a single senator can object. So let's take this all apart, and let's assume that there is some sort of problem with the slate that has been sent from a state to Washington. What's the process now? Credibly speaking, what is it trying to address, and does it effectively do that?
Yes. So the process now is that everything has to be in writing. You have to have a written objection clearly laying out your theory of what's wrong with the slate. They go one by one reading through them. So you wait alphabetically until you get to Pennsylvania or whatever state you want to challenge. You present the vice president with this signed paper, the senator and a member of Congress signing it. And then if it's valid, if it's signed, the two houses immediately separate. They go back to their separate chambers. They debate with this 2-hour time limit and a 5-minute time limit on any individual member speaking. And then they vote up or down. The text of the statute is vague on what's a valid challenge and what's not. And that unfortunately has given leeway to some members to say, well, we can make any kind of challenge we want. I would say that used in the best way, it's a stopgap against corrupt states. So suppose some state's governor just hijacks the whole process for himself, pushes out the board of electors, says, I'm convinced I know who won this, and just sends a slate to Congress and doesn't let anyone else send a slate to Congress. That would be the kind of, pull lever in case of emergency scenario where Congress should toss out those votes that were clearly fraudulent. Or say in an extremely unlikely event that a slate of electors was bribed. There's there's clear evidence that they just voted corruptly, they sold their votes. Then Congress could validly choose to toss those out. And I think if something like that happened, you would have bipartisan support for tossing those out. And so that's why some people have suggested perhaps the threshold should be raised beyond just a bare majority, that if there's ever a time to validly toss out a vote, it should be so clear that both parties would agree that these votes just can't be counted. But the biggest problem with the current version, and the thing that needs to be changed if it's reformed, is to spell what I'm talking about now, list what is a valid reason to toss out a vote. It was a bribery. It was not cast on the right day. It was not certified by the board of electors, et cetera. And so the Congress knows anything besides what's on that list is not valid reason to challenge.
Let's Let's just go down that rabbit hole a little bit further. Let's assume there is a corrupt governor who sends a invalid slate. There's an objection, and that objection is sustained. Let's call it Pennsylvania. What happens to those votes, and then what happens to the election?
Well, under the Electoral Count Act, simply, I don't know the exact term it uses, today we'll say something like discounted, tossed out. They're not part of the total. So everybody knows from like 538.com that the total number of electoral votes is 538, which normally means you need a majority, 270 to win. There is some debate, some uncertainty. If you toss out votes, does it affect the so-called denominator, the total? So if I toss out a state with 38, if I toss out 38 electoral votes, do you still need 270 to win? Is it sort of 270 out of the 538 that were tried to be cast? Or do you now just have 500 total, so now you only need 251 to win? So one of the proposals for reforming the Electoral Count Act is to make that explicit. My own view is that if you're tossing out, if a vote was validly cast, but there's a problem with the vote itself, you should include that in the denominator, the total. If a vote was not even validly cast, say the elector was ineligible to be an elector, that should not be part of the total because the elector was really never even validly appointed. But in any event, you do the math, you hopefully know what the denominator is, and you see whether anyone has won a majority with that new math, be it, if you're down to 500, has anyone won 251 out of 500? And if no one has won a majority, the Constitution says you go to the House of Representatives for what's called a contingent election, which is where they take the top three electoral vote getters and they vote congressman by congressman, but with each state counting equally. So all the 50 odd members from California only have one collective vote. Whoever wins the majority of them, the one member from Wyoming and North Dakota and South Dakota each have one vote. And so whoever eventually wins 26 states becomes president.
Interesting, thank you. And I'm impressed by your ability to do that math on the fly. There's no calculator scene.
Well, that's why I picked 38 to get down to 500 even.
Wonderful. Okay, fair enough. All right, so let's talk about, we've really explored what the challenges with the current Electoral Count Act is and how it played into the 2020 dispute. Let's talk about how, where we haven't already covered it, how the new, I believe it's a Democrat senator group that is trying to develop a new act called the Electoral Count Modernization Act. It's presumably going to address all the concerns we've already discussed. Let's, if you will, take us through where you see the key elements, what they're getting right, and what, in order of importance.
Sure. So I think the most important thing they're getting right is that they are listing out the valid grounds for a challenge. I think that's absolutely key because it tells, the most important thing is to tell members of Congress in advance, this isn't about relitigating the election. We can't have challenges like we had in 2020, where Josh Hawley is saying, there was widespread fraud in 5 states. And even though the courts didn't find it, we're going to throw these ballots out anyway because we're convinced that there's fraud. That's just should not be a valid grounds for objection. Another thing they get right, in my view, is raise the threshold to make a challenge. I think one from senator and one member of Congress is way too low. It allows crackpot challenges to take up 2+ hours of Congress's time and just could, as we saw in January 2021, fan the flames of uncertainty. It raises the threshold to 1/3 each. We can debate where that threshold should be. At Cato, we've suggested 1/5. Wherever you end up putting that, something well above one person in each house is absolutely key. It also spells out more explicitly how you go through litigation in the courts to settle these issues. I think that that's on the right track. I think it overcomplicates things a little bit. It gives what's known as a cause of action, which is kind of the right to bring a lawsuit to a lot of different people. I don't think that's really necessary. I think you can simply leave it to the candidates to bring the lawsuits related to who's a valid elector. So there are some details about how it is how it would create new systems in the courts that I think can be objected to. But on the whole, I think it's a good start. And I think even those who proposed it admit that this is the starting point, not the finishing line.
There's also a lot, you've written quite a bit on ensuring the timeline. We've got an early November election, and we've got the count of those electoral ballots January 6th. It would change or speed up or insist that certain resolutions occur long before we're in the position of counting ballots. Is that right?
Yeah, that's a great point. And that is something else that I think would be a big improvement. A lot of people forget that we only have had a January 20th inauguration day since 1933, the 20th Amendment. Before that amendment was passed, inauguration day was March 4th. There was much more time for courts to deal with these issues. And so before 1933, everything was later in the calendar. The count was later. It was in February rather than January. The electors met later. And the Electoral Count Act explicitly pushed later in the calendar when the electors met with the express reason to give the courts more time. And I think we can do that today. So I believe the Modernization Act pushes it back to late December when the electors meet, the deadline for any court challenges to finish up and for this final slate from each state to be finalized. And I think that's an improvement. You really don't need this gap time between the electors voting and Congress meeting to count. Nothing is happening there except the ballots traveling by mail, which hopefully even the Postal Service can get that done in 6 days. Some may have their doubts, but hopefully that's not too much to ask.
Yeah. Well, it's not the Pony Express. Right.
It's more important to have more time for litigation, both to get it right, and second, to get the appearance of getting it right. I think too many people had a talking point, both this year and in 2000, Bush v. Gore, that they didn't trust the court decisions because they seemed rushed, because they have this tight window of about a month. And so if it can build more trust and more faith in the litigation and in the court process, that's a good in itself, because you're less likely to have the strife that we saw on January 6th.
Sure. This might be getting too much into the weeds, but you even talk about what the act should do in the eventuality that the candidate that gets the most electors either dies, or there's been some talk about eligibility. If it's found that the person who's been elected may be subject to a case of sedition or something like this, whether that candidate could be invalidated. Does it speak to this as well?
Yeah, that's a great point. So the current draft, I think, does not sufficiently address this succession issue. And again, these are all very unlikely, but as we've seen, unlikely events can happen. So better to address them in advance rather than get caught off guard when they do happen. One of the 20th Amendment, which I just mentioned, most famous for moving up inauguration day, much less famous for another change, but could be just as important. It clarifies that if the president-elect dies before inauguration day, the vice president-elect gets sworn in. Before that amendment, it was kind of unknown how you would deal with that scenario. And we almost had that happen once. 1872 election, Democratic nominee Horace Greeley lost the election and then died about a month later. So luckily he didn't win and we didn't have a crisis. But if he had won, we would have had a constitutional crisis. 20th Amendment clearly lays out if the president-elect dies or fails to qualify. So that's, the unlikely event that we suddenly discover, oh no, this person is not a natural born citizen, or this person is under 35, which is the minimum age in the Constitution. Or as you suggested, the 14th Amendment bans anyone who engaged in sedition. It could be a court or whoever decides that this person is ineligible. In all of those scenarios, the vice president-elect is supposed to act as president. And that makes sense, and that's correct, because the same party, it keeps the White House with the party that won the general election. And that's the principle behind it. So that makes democratic sense. The problem is that if the Electoral Count Act is used instead, if you toss out all the votes for that dead winner or the ineligible winner, you hand the White House to the opposing party. They're the only ones with any electoral votes left standing. So that's undemocratic, one. And two, it's kind of arbitrary, right? Because if the death happens or if the ineligibility is discovered before the count, you toss him out, the White House switches parties. If the death or the ineligibility occurs after the count, 20th Amendment kicks in no matter what. It's your only option. Vice president-elect becomes president. So what I think Congress needs to focus on and make explicit is that you do count the votes, even for a dead person or even for a not eligible person, and then you make the vice president get sworn in.
Now, your paper even talks about, we're having this conversation in the context of some legislation that really did try to federalize much of the role of elections instead of leaving those powers with the states. You do go into some detail as to which elements of the election the act should not take away or usurp from a state level, meaning hands off the state's prerogatives at a certain level. What are some of the things you want to make sure the act doesn't do with regard to states' prerogatives?
Sure. So first of all, the Constitution makes clear that the states are the ones who are deciding the procedure for the votes. So how the manner in which the electors are selected, and that includes the manner in which the general election is conducted. So you don't want a bill that has essentially setting out requirements for how the electors are decided or how the general election is conducted, or that sets out standards of review that kind of presume that there's a right way or a wrong way to have the election. So really the standard should be state law governs, and then whether the election was valid or not is judged against the pre-existing state law. So the proper role for the federal government is really just to make sure that the rules are fair and decided in advance. So a proper role is to say, whatever rules you set, don't change them after the game. So I think it would be totally valid to say, state, you can't suddenly after election day say, you know what, never mind, we'd actually prefer to have our legislature decide who our electors are because we don't like how the general election went. That should be out. So I'm totally in favor of setting a hard date. November, first Tuesday in November is election day. Whatever procedure you have in place on that day is what you stick with. No changing the rules if you don't like it.
Now, I mentioned at the top of the show that this is an initiative. This Electoral Count Modernization Act is a Democrat initiative, but there are some Republicans joining in the conversation, in the debate. A rare incidence of bipartisanship. We've talked a little bit, you and I just now, about the benefits of having a more clear process, and that it doesn't tempt any kind of let's say frivolous challenge. Say more about why you think it's really in the Republicans' interest to join the fight and ensure that this reform moves forward.
Absolutely. So any rule that you're setting in advance, any flawed rule, you never know who's going to exploit it or which side is going to benefit from it. So all of the calls in 2020 for Mike Pence to seize power, overturn the election unilaterally, toss out votes, those calls just as easily could come to a Democratic vice president in a future election. Fair is fair, whichever side might benefit from it. And Republicans often voice support for the Electoral College in general. There's a lot of calls, many of it coming from the left, to toss out the Electoral College system entirely, go to just a nationwide popular vote. I think Republicans have valid concerns, valid reasons to prefer keeping the Electoral College system, ensure that you have that people care about smaller, more rural states. That was the framers' original intention. And a robust and fair Electoral Count Act is key to maintaining faith in the Electoral College system. The more people think this is a game that can be rigged, the more likely they are to maybe say, why not just toss out the whole system entirely and go to a nationwide popular vote? And so I think if Republicans want to support keeping an Electoral College, they should want a legal framework that makes clear that we're going to respect the outcome of the vote as decided by the Electoral College, as decided by validly selected and chosen electors.
Now, the presidential election is still 2.5 years away, not that far. We're in the debate stage of these reforms to the Electoral College. Is there a deadline before which the act must be passed in order to be binding on this upcoming election? If the clock is ticking, what's our deadline?
Legally, there's two answers, legally and politically. Legally, I don't think there's really any deadline other than election day 2024 itself. The rules, it would not be ideal to change the rules of the road that close to it, but I think legally, whatever rules are in place on that day is all that matters. Politically is a very different question. The closer you get to the heat of battle, especially once it's known who the candidates are, in my view, the less likely it is that something's going to be passed. Everyone's going to be more risk averse. Everyone's going to think, is this going to hurt us more than it helps us? You could have a particular candidate who's not a fan of reforming the Electoral Count Act, who's a candidate for one or both parties. So I think it's much better. I think pragmatically, it would be much better to pass it this year before even the midterm election, because midterm is the unofficial start of the presidential campaign, essentially the day after the midterms. And so right now, when we don't know who the nominee, at least of the Republicans, is going to be, when we don't have any specific controversies already ramping up about how states choose their electors or about early voting or any of that, this is the best time to kind of stay in the veil of ignorance, when both sides should realize it's in their rational self-interest to create rules that are fairer for both sides and are more likely to benefit than harm both sides in the long run.
So if we are ever sober and rational, this is the moment. We become gradually less so as election day approaches. I'm sure we've piqued the interest of our listeners on this topic. I've said I've enjoyed your writing and research on the issue. For our listeners who want to learn more or follow you or keep up to date with the progress of this reform of this very, very important Electoral College Modernization Act, where can they find your work on the topic?
Absolutely. I'm just one of the folks at Cato who's been interested in this. I'd highly commend the work of Andy Craig, my colleague, a writer at Cato. He's been writing a series of blog posts at the Cato at Liberty blog. So I'd encourage everyone to search Cato at Liberty and you'll find the blog. You can also search. So if you go to my page, cato.org/people/Thomas-Berry. You'll see all of my writings in general, including my blog posts on this. Or you can just go to Cato and search Electoral Count Act, and you'll see the long list of writings by me, by my colleague Andy Craig, and also my colleague Walter Olson has written in particular about why Republicans and people of all stripes should support this election reform in particular. And as you've said, we have one proposal now. It seems likely that in the near future, we'll have a second proposal by a group led by Susan Collins and Joe Manchin, and we're likely to have one from the House as well. So we're planning to respond in detail to each of those, lay out what we think works and doesn't work. And hopefully this is going to be an active process through the next couple of months when Congress is likely to be considering and perhaps voting on them.
Well, maybe it's too early to celebrate, but I'd like to just rejoice in the notion that we can actually in Congress agree on something and reach across the aisle and find a solution, a potential solution for what had seemed like an intractable issue. So this is very exciting, I'm sure, to our listeners on both sides of the aisle. Thank you very much for taking your valuable time with us, Tommy. You've been a real fund of information and a subject matter expert like no other. Thank you very much.
Oh, thank you. That's too kind. I really enjoyed it.
This has been another episode of Hubwonk, a podcast of Pioneer Institute. If you enjoyed today's show, there are several ways to support us and Pioneer. It would be easier for you and better for us if you subscribe to Hubwonk on your iTunes podcatcher. If you'd like to help it make it easier for others to find Hubwonk, it would be great if you offer a 5-star rating or a favorable review. If you have ideas or comments or suggestions for me about future episode topics, you're welcome to email me at hubwonk@pioneerinstitute.org. Please join me next week for a new episode of Hubwonk.